Clemson University employee is without a job, and two others are under investigation this morning after comments about political influencer Charlie Kirk's death.
And the school has been under political pressure from Republican leaders on the state and federal level to take stronger action against their employees.
Also new at noon, Gaston County school leaders now say they're now reviewing comments made by a school employee following Kirk's assassination. So in a statement to Queen City News, Board of Education leaders say an employee posted an insensitive comment on social media regarding the tragedy that occurred yesterday. And the school system is now reviewing the incident, and leaders say that the Human Resources Department is also working to conduct their own investigation. So the exact nature of the comments, though, is unknown at this time. This is a developing story. We'll bring you the latest both on air and also online at qcnews.com.
And social media reactions to the shooting are fueling political discussions. Some comments are drawing the attention of employers. Queen City News anchor Savannah Rudisill joins us now with why jobs are now on the line for people in the Carolinas.
Teachers, elected leaders, and a cable news contributor could lose their jobs for comments made online just within 24 hours after the conservative activist's death. One of the confirmed firings was made within the Panthers organization. Now, the team let go of a communications coordinator. The former employee referenced a now viral comment that Kirk made in 2023 in front of a Turning Point USA crowd, saying that some gun deaths were, quote, worth it in order to protect Americans' right to bear arms. Panthers officials said in a statement that, quote, the views expressed by our employee are their own and do not represent those of the Carolina Panthers. We do not condone violence of any kind. Now, two area teachers are also facing consequences for similar online comments. A Lake Norman Charter High School math teacher is on administrative leave, and a Gaston County teacher is under a board investigation. Constitutional law and free speech experts say the law protects individuals from government backlash, but not from workplace decisions.
There is no constitutional protection when your private employer tells you that you cannot speak or sanctions you for something that you said in social media or in a protest somewhere.
MSNBC political analyst Matthew Dowd lost his spot with the network for remarks seeming to blame Kirk's, quote, hateful words as the cause for the, quote, hateful action. He and network executives have apologized for those comments.
Clemson University employee is without a job, and two others are under investigation this morning after comments about political influencer Charlie Kirk's death.
And the school has been under political pressure from Republican leaders on the state and federal level to take stronger action against their employees. Some leaders threatened to even pull the school's funding. South Carolina's Republican Attorney General Alan Wilson, who is also running for governor, also sent Clemson's president a letter.
It says in part the First Amendment protects freedom of speech, but it does not shield threats, glorification of violence, or behavior that undermines the mission of our state institutions, end quote. Wilson also clarified that under state law, the school would not face criminal prosecution if the university fired faculty over the social media post, and that legal action on a civil level was a possibility.
Meanwhile, in California, a College of Sequoia's biology professor is under investigation after a student recorded him making controversial remarks about political commentator Charlie Kirk and his family during a lab day class. Take a listen.
Yeah, I hope every one of his family dies, and their children, and their grandchildren, and their grandchildren, and their grandchildren to eternity.
All right, so kind of hard to listen to all of this, and we're getting flooded with it on social media. So we want to bring in Chief Legal Analyst Collie Froats to talk about these cases locally here in the Charlotte region and across the country. You touched on it last week that there is a big difference in someone who works for a private company and what is federally protected here. So what can you kind of make of all of this that's going on, especially at an institution like Clemson that does receive federal funding?
I would have loved you when I was a professor as a student because you paid attention to last week's class, so it made me feel like
A+.
But no, seriously, these type of things, this conversation is something that's great for law school and now real world application. As I mentioned before, public versus private, that's the key focal point that you'd have to look at. And so, yeah, if you're a private citizen, if you're employed by a private company, you have zero to little protection protections in terms of the First Amendment. But if you're in a public setting, if you are a public employee, it's a different approach. And the standard is, are you talking about something that is a matter of public concern? Are you working as a forester and you're talking about, I don't like the fact that we're cutting down trees? Now that may be something that will be a higher level of protection because you're in that job and you're talking about your specific job. Additionally, if you are talking about things outside of the scope of your job, maybe on social media, you'd think that you would assume based on court law and precedent that you'd have even heightened protections because you're away from the job. Now, the issue is, and Alan Wilson talked about it there, you can't make threats. The second part of his statement, I'm not sure if that's what the First Amendment says, and I haven't seen much precedent that talks about the glorification of types of things, because you can have a First Amendment a right to negative things that I don't agree with, and it is still protected. It just can't bring other folks to violence. So I can't do things that are inciting violence. I can't make threats of violence. Yeah, those are clearly not protected. But the glorification, my view of it versus someone else's view may be entirely different. So I think that's a little bit misleading with his statement of that second portion. Completely agree with the first part of that. There's a number of cases that support that statement. But the second one, I think that would be viewpoint specific. I'm saying I don't like your viewpoint. And because I don't like your viewpoint, I'm going to terminate you. I think that would actually go against what the Constitution says.
So I feel like there's fear swimming around, like on all sides, fearful of people saying, I want to be able to say my truth without the fear of being fired. You got people on the other side that are maybe defending Kirk and what he stood for or what he said, and they're fearful that the other side's going to retaliate against them. So there's fear on all sides. Yesterday, Vice President J.D. Vance was on the Charlie Kirk podcast. He's now calling for people to basically turn coworkers in if they hear speech that sounds threatening or that someone might be celebrating the assassination. Any protections there? I mean, what about the person who's turning them in or the person who's being turned in?
This part of the conversation, if this was a brief, I'd say I'd incorporate my previous statements, right? So all of my previous statements, I'll incorporate in this. We're talking about, in this instance, a public employee. If we're talking about private employees, nothing that I'm saying right here would apply. But if you're a public employee, someone that works for the federal government, someone that works in state employment office, and you're in any capacity like that, I believe the government cannot chill your speech unless they show a compelling public interest, unless it's narrowly tailored, and they go through a number of other hurdles they got to do that. And so in this scenario where you're saying you're going to challenge and go after someone because of what they're saying and the content of what they're saying, that is content specific. And if you're attempting to chill speech, it has to be content neutral. And so I think that is a clear violation of the First Amendment. You telling individuals to look for and look out for certain types of speech and to now whistle blow on their speech, the specific type of speech, the content of their speech, that is a clear violation of the First Amendment.
But looking at South Carolina, if the Attorney General's already said, you're not going to see any legal prosecution. Now, he did make a note that civil matters, that there's no guaranteeing there's protections there. So how do you decide what to do if the AG of your state is saying, no, don't worry, you can fire them and it's not a violation?
I just think that he's setting them up for a lengthy amount of lawsuits. If you're saying that you can terminate someone for content-specific speech, not content neutral, then I think he's giving them misguided information, specifically based on the hundreds of cases that have come before our Supreme Court, our highest court in the land, that have talked about the limitations on speech, specifically content specific. These are not content neutral. He's making recommendations, Alan Wilson, in this scenario, of going against individuals for content specific speech, specifically talking about an individual, Charlie Kirk, and what you're saying about that individual, your specific speech. There is a mountain of case law that says you cannot do that. And unless you are narrowly tailored, compelling public interest, and a number of other things, and they wouldn't be able to point to that. So I think that right there is misleading in terms of that memo. I had a chance to read it. I agree with the threats, the violence, but everything else in there is not accurate in terms of what case law says.
Yeah, going back to school on what the First Amendment allows and does not allow. So, Khalif, thank you so much for that.
Welcome back. Time is 8:14 here. We want to get to a story as we continue our coverage of Charlie Kirk's assassination and the fallout from that. Secretary of State Marco Rubio recently said visa revocations are underway for foreign visitors celebrating the assassination of Kirk. Kirk was fatally shot at an event on the campus of Utah Valley University last week. The conservative activist and Turning Point USA founder was a close ally of President Trump and other administration officials. Now, during an interview with Fox News on Monday, Rubio said that the State Department will not grant visas to those celebrating Kirk's death and will revoke visas from those doing so. We want to bring back in our chief legal analyst, Charlie Kirk. We've talked about the Secretary of State's position on different visa holders celebrating things like the war in Gaza and what they would do to people in that situation. First, let's start here. What's his legal authority to for visa holders that are currently in the United States? Not talking about approving them, but people here. Right now.
Well, approving current people that are residing here or people that are actually attempting to come in, it's within his discretion. So I'll start there. But the main question is when we're in court and we're trying to get evidence in, the court has to make a determination as if it's inadmissible or if it's admissible. That's the same question that they're asking. Our founders of our laws really weren't creative with looking for new ways for terminology. And so admissibility is the key factor. The State Department is going to make a determination, is this person admissible or are they inadmissible? And so that can fluctuate. You may have been admissible prior to coming into the country. They granted you a visa. And then at some point now you have been deemed to be inadmissible. Something has occurred. Specifically, if we're looking at social media posts, for instance, you've done something to support some terroristic organization historically in the past. That is what would have been sufficient for the court to be able to determine that now you're no longer admissible, and then they can go and start the process for revoking your visa. Not automatically going to start the deportation process. Normally what would occur is that your visa would be revoked. Then you'd have a deportation hearing. And at that hearing, you'd be able to defend or prove and fight why you should not be removed because of the statements or the allegations that are against you. But to your original question, yes, 100% within the discretion of the Secretary of State to do that.
Okay, when we talk about, supporting terrorist organizations, obviously everybody has condemned the assassination of Charlie Kirk. What freedom do visa holders have to not celebrate, but to have freedom of speech?
That's an excellent question, and this would be a law school type of question. If I was still teaching, I would love to use this example as a testing challenge to kids' ability or students' ability to be able to decipher the law and then apply it to a different set of facts. And so in this scenario, you raised the First Amendment question. Are there First Amendment protections for speech? I mean, yes, we know that you've given First Amendment rights for speech as a citizen. So then the deeper question is, does a person that holds a visa have First Amendment protections? And it's broken down into two places. Outside of the country, no protections for First Amendment. Once you're in the country, yes, there is case law to support a visa holder having First Amendment protections. So then you may ask, well, what are the protections and how may I be, shrouded in the same protections as you or I as an American citizen? Not as much, but there are protections. The standard is just lower. If it's a First Amendment argument and the State Department is saying that I'm going to limit this visa holder's ability to speak and I'm going to challenge their removal or their granting of a visa because of something they said, the standard of review is that they have to be able to point to, the government does, a facially legitimate and bona fide reason. That's all they have to say for why they're denying your entry or your keeping of a visa, connecting it to your speech. And so if it was you or I and they were saying, hey, I'm going to limit your speech, it's going to be a way higher standard, compelling public interest, narrowly tailored. It's going to be the highest standard, strict scrutiny. In this scenario, it's going to be basically floor level. And the courts have held continuously that we can limit a person's attempt to get a visa based on their speech, even if they have free speech protection.
Is there any argument if it's not applied fairly across the board? And I'll add to my question, say a visa holder celebrated the assassination of Melissa Hortman. Would they be then say, okay, well, you didn't deport this person or revoke their visa because they celebrated the assassination of a Democratic leader, but you're deporting somebody who's celebrating the assassination of Charlie Kirk? It needs to be fair.
That is an amazing question. Again, a law school 101. It normally, when you are attempting to limit, chill, or slow down a person's speech, it has to be content neutral. It has to be, I can't specifically say, I didn't want the red wall, but I wanted the blue wall, so I'll exclude all the folks that like the red wall. Now you've targeted their specific speech. And so historically, the courts have said if it's going to be targeted towards not content neutral, then you will have a problem. But again, if they can get to that hurdle of facially legitimate reason, then it doesn't matter. One case I can cite to you is that there's this Mandel case, happened in the 70s. A professor wanted to come speak at an institution, and they didn't want to let him come speak because of things he had said in the past. Well, every case since then, they've used that Mandel standard. I've said before that speech isn't just what you say, isn't just what you wear, but it's also your ability and my ability to hear other people speak. So professors sued and said, hey, you're stopping this speaker from coming, and you're denying me, an American citizen, their First Amendment right to hear him. The courts went right back to Mandel and said, well, they don't have to do that high standard. It's the lowest standard. Right. And because of that, we can deny his ability.
Okay, we're also following some breaking news right now out of Kentucky. Officials there say a North Carolina man made threats of mass violence against the University of Louisville in the aftermath of Charlie Kirk's death. So officers arrested 18-year-old Michael Tedder, who you see right here, 2 days after Kirk's assassination at the Utah University. So Tedder is now from Advance, North Carolina in Davie County, and that's the Piedmont Triad area. Investigators now say they traced a disturbing call to Tedder's address in the Tar Heel State. He's accused of referencing that he'll use an AR and AK-style rifles if the university did not remove controversial posters that feature Charlie Kirk after his death. Tedder is now charged with communicating a threat of mass violence on education property.
Queen City News Plus. Just search Queen City News on your smart TV's app store.